Good afternoon. Welcome again to ChrisChat. We'll let things populate a little bit. It is ChrisChat number 3. Thank you for all of you who have popped in previously to the first 2, and thank you for that. The idea here is to educate, not to advocate, although I will answer questions, and if you ask my opinion on things, I will give them, of course. But the idea here is for people to be better educated. We work better when we are educated as an electorate. So that's the idea here, especially with issues like we're going to talk about today, which is the First Amendment and the Free Exercise Clause, as well as discussing Religious Freedom Restoration Acts, which are now coming back into, or certainly being pushed much more in individual states. So we will be talking about those as well. What I want to get to first, in order for you to understand what we're looking at in terms of free exercise of religion, there are a couple of things you have to be aware of. I mean, there are different types of exercise of religion, and how you do that. And they can be benign all the way up to being rather severe. Roman Catholics drinking a representation of the body and blood of Christ. There are people who, in the Mormon faith, in the Church of Latter-day Saints, wearing the temple garments, which are believed to deflect evil and things of that nature. We have Scientologists who believe in e-meters and trusting that, and those are relatively benign exercises of faith. And then you go further in exercise, talking about in India and certain sects in India, the Maharashtra do what's called a baby throwing, where they go up to a 50-foot tower and they drop infants off the tower to be caught by men holding sheets at the bottom. We have people in the Philippines who every Easter nail themselves to crosses. But right here in America, we have people who practice Santeria faith, who have been restricted from doing so because part of that faith is that they engage in live animal slaughter. And even folks like Rastafarians and Native Americans, certain Native American sects who utilize what the federal government deems to be illegal drugs, marijuana or peyote, both of which are restrictions potentially on their free exercise of religion. So what we see now is what I want to talk about now is how the First Amendment's protection of the free exercise of religion is balanced against the power of the state. It's something important that you need to address. First, in order for me to help you and for you to know what the words are, you have to be aware of certain buzzwords. First, you have to define what a religion is, and that has in fact been defined already. The United States Supreme Court in U.S. versus Seeger dealt with a case involving a conscientious objector who, when he was pressed on his beliefs regarding God, he said he didn't necessarily believe in God, but he did believe in a higher power, a higher authority. And so his conscientious objector status was tossed. But the United States Supreme Court allowed it ultimately, and allowed him to have his conscientious objector status, and in the process created a definition of what religion is. First, it has to be a belief in a God or godlike thing, other supreme being, something that takes the place of what God would be to anybody who would normally get a conscientious objector relief. So he didn't believe in God per se, but he believed in a higher power. There has to be some moral code is the second part that goes along with this, that just goes beyond the individual preference of in this particular case, I don't want to go to war. What it had to be was something that was greater than himself, something held by others, and that's the third test. Some degree of association or community of belief in this same thing. And fourth, and this is the important part here when you're dealing with what a religion is, this belief in a God or this belief in a moral compass or moral structure has to be, and this is the key buzzword here, a sincerely held belief. It can't just be something you make up. It has to be sincerely held. And in fact, the United States Supreme Court in Seeger said that once someone states that it's a sincerely held belief, you shouldn't go beyond that. There's no test for sincerely held, certainly not at the Supreme Court level. So when you're talking about a religion, you're looking first at whether something qualifies or not. The second thing you have to be aware of in terms of these laws that we're going to talk about, these Religious Freedom Restoration Acts, what you have to be aware of is that there's a certain degree of scrutiny, that there are levels of scrutiny when you're talking about protection of your religious rights. And there are different levels of protection. The first level being strict scrutiny, where if you pass a law that affects someone's fundamental rights, if you pass a law that affects someone's, that's based on ethnicity, based on their race, based on their national origin, or their religion, or their religious belief, at that point, if you pass a law that affects it, that law has to have a compelling state interest to do so. And the law that you've passed has to be the least possibly restrictive thing that you can do to affect that religious belief. There's a second level of scrutiny it's called heightened scrutiny or middle tier scrutiny. This usually deals with cases regarding gender or illegitimacy or something of that nature. But that requires a lesser degree of scrutiny. And if you don't reach that suspect class, and we're going to talk about the Religious Freedom Restoration Acts and what counts as a class. If you don't, then all the state has to do is prove that this law that they have passed has some rational basis and some connection to this rational state interest. So that's it. So when you talk about these different laws and how they affect you, or how they will affect certain groups, that's the test. You're going to hear that strict scrutiny and compelling state interest test as we go through this. We've talked about Seeger. What you have to be aware of now is that this religious freedom, dealing with the free exercise clause, has sort of been swinging on a pendulum for the past 120, 130 years or so now. I mean, it's gone from an extreme against it to a period in the 1960s and 70s where there was much more protection for people who cited religious grounds for certain behaviors. And now we've seen a swing away in terms of what the Supreme Court allows. But what this has resulted in is a pattern of legislation that goes against the Supreme Court. So let me give you a brief synopsis as to what the Supreme Court said over the course of time that deals with what we have right now. The United States Supreme Court didn't really have to address the free exercise clause until the late 1800s, 1878, dealing with the case of United States versus Reynolds. Reynolds was a Utah Mormon. He was a person who was an elder in their church, and as many of you are aware, then and in some cases now, the Mormon church believed in polygamy, and there was and still is a federal law prohibiting polygamous relationships. He contested that and said that this violated his rights under the Equal Protection Clause to practice his faith. What the Supreme Court said at that point was that it protects your beliefs, but it does not necessarily protect the practices of your beliefs. And that if this law that you're talking about is neutrally applied to everybody and is not specifically meant to attack your faith, then you're not protected. Your religious freedom, your right to free exercise goes out the window. That was the standard of the law until we get into the 1960s. And as we'll talk about hopefully in the future, the 50s and the 60s was a time of great upheaval and a lot of change in the law, certainly regarding individual freedoms. And one of those individual freedoms that the Supreme Court got themselves into deeply was religious freedom. In the 1960s, the court adopted a much more expansive view of free exercise. It dealt first with the case of Adele Sherbert Funny name, I know, but so be it. Adele Sherbert was a Seventh-day Adventist. And Seventh-day Adventists, for those who don't know, are people, a sect of Christianity that chooses Saturday as their Sabbath day. And as part of their Sabbath, they're not permitted to work on the Sabbath. Adele worked in a fabric shop, or a textile mill, excuse me, and she was told that she would then have to work on Saturdays, and she refused, and she was fired as a result of it. So when she sought unemployment benefits, they said that she was fired for cause, and she pursued an action under the Equal Protection Clause regarding this violation of her religious freedom. And the United States Supreme Court at that point said that the Free Exercise Clause means that any government action against you and against your religious practice must have a compelling state interest, and that the action that they take must be the least possible burden on your practice. So as a result, application of this strict scrutiny law allowed her to get her unemployment benefits. She was turned down, and then they gave her her benefits. And this, in fact, created the new test for what the Free Exercise Clause protected and what it required. It required any government action against you to have a compelling state interest. Any law that dealt with religion, at least your free exercise of it, required that there be a compelling state interest to do so. And this resulted in shooting down a lot of legislation that dealt with religious freedom and religious exercise. There was another case of a gentleman who worked in he worked for, I believe it was McDonnell Douglas, and as a result of him working in McDonnell Douglas, one of his jobs, or one of the things that they did there, was build missiles. He was a Quaker, and he is a pacifist as a result of his faith, or as part of his faith. And so when they transferred him from his job building airplanes to moving him into the missile wing, he told them no. And he was fired as a result, and he went to get unemployment benefits. And again, based on this Sherbert compelling state interest test, he was allowed to get his unemployment benefits at that point. Again, this law did not apply. He was protected. His interest was protected. So this went on for a period of time where the test was any state action against your free exercise had to have this compelling state interest. Then we get into the late 80s and early 1990s. And there was, after this, a swing back from the previous standard of requiring this compelling state interest to something less protective of religious freedom. In essence, a swing back to what they had originally talked about in Reynolds. I've written about this before, but I'll repeat it again. This dealt with a case of Alfred Smith. Alfred Smith was a Native American. He worked as a drug treatment counselor. But as part of his Native American faith, he believed in the ingestion of peyote to allow him to reach a higher plane of consciousness as part of his religious practice. Peyote is an illegal drug, and as a result, he took a drug test as part of his job, and they discovered this in his system, and as a result, they fired him. He went to get his unemployment benefits. It seems it always comes around to unemployment with these early cases, or at least the foundational cases. And after he went and applied, he was denied. And he proceeded to bring the case all the way through up to the United States Supreme Court, again saying that this government action, this denial of benefits, violated his free exercise, that he, based on what he believed to be the case, or at least for his practice, that he was allowed to utilize peyote and that this shouldn't restrict his free exercise. The United States Supreme Court rejected his claim at that point. 1990, Employment Division versus Smith is the case. And the majority decision in that case was written by Justice Scalia, the now deceased Justice Scalia. And he, at that point, said that if you have a law such as the peyote law, rendering that you couldn't take these drugs, that this was an illegal drug. And this particular law was neutrally applied to everyone, that this was a general, neutral law that was not specifically directed at a religious practice. That when you have a generally applied, neutral law that applies to everyone, if it happens to touch on or affect your religious practice, your free exercise claim is not acceptable. The court reinterpreted a lot of cases as a result of that, but the standard at that point was that a generally apply, and that's the standard now under current federal law as far as the Supreme Court is concerned, that if it is a generally applied law, applicable in that case to criminal stuff, but it happens in civil aspects as well. If it's a generally applied law that tangentially affects your religious free exercise, then your free exercise is trumped by that law. In essence, it tossed out 50 years of compelling state interest tests. As a result of Smith, this is now where we get into the problem, or some people see it as a problem, with Religious Freedom Restoration Acts. You have a number of these that have been passed throughout the states. The first one was passed through the United States Congress in 1993, directly as a result of this decision in Employment Division versus Smith. This was bipartisan. It was signed by President Clinton in 1993 into law, and had bipartisan support across both aisles, and the votes were tremendously in favor of this Religious Freedom Restoration Act. It meant initially to affect both the federal government and the states. The United States Supreme Court said that this was an overreach by the federal government and would only apply to federal laws that dealt with this. But what these religious freedom, at least the first one and all of those since, the basic foundation of it is a reversion back to what that original test was. A reversion back to requiring that there be some compelling state interest if there's any law that affects your religious exercise. And that's what resulted in a number of states having their own Religious Freedom Restoration Acts. We have right now over 20 states, including the federal government, that have these Religious Freedom Restoration Acts in place. And there are certain things that you have to know related to these Religious Freedom Restoration Acts. At any point during our talk, if you have questions specifically about this, please chime in, let me know. As I said, these laws were directly as a result of this Employment Division case in 1990, the Scalia decision, which chucked compelling state interest. The laws were, at the federal level, initially intended to go back to that compelling state interest test. What we're seeing now, however, and what is the more objectionable or potentially objectionable issue for civil rights advocates anyway, is that laws like the one that was passed in Indiana back in 2015 and signed by now the Vice President-elect Mike Pence, a law similar to it in Arkansas, there's one now in Texas. More and more states are having their own RFRAs. You'll hear that term, but it stands for Religious Freedom Restoration Act. And these RFRAs are meant to bring that compelling state interest test back. The problem with these new states, however, or at least these new statutes in states, is that they are broadening the potential impact, where initially these, at least the federal RFRA, was meant as a protection of religious minorities. What the fear is now, and it's becoming much more of a founded fear, is that these laws will be used by majority religious groups to pursue actions that are against other types of minorities, which we'll talk about. The Indiana and Arkansas law expands that original federal structure and applies religious rights to corporations. It applies to private lawsuits and not just what a government or state action is concerned. All of them have a common structure. If people feel that a state action, like a fine or a mandate imposes a severe burden on your religious freedom, then you can go to court and a judge can determine whether or not your practice has been violated and whether this law satisfies a compelling state interest and is the least burdensome method by which to satisfy that government interest. That's really the standard. The controversy comes in how they're being applied. And they have good application. They do. Initially, like I said, they were meant to protect individuals from being discriminated against because of their religious practice, not using it to discriminate based on a religious practice. Just this past year in the Hobbs case, dealt with a Muslim prisoner in a federal court that as part of his faith, he's required to have his beard reach a certain length. But based on prison standards, he wasn't allowed to keep his beard that long. He sued under the free exercise clause, and ultimately the Religious Freedom Restoration Act said, yes, he's permitted to allow his beard to grow beyond the half-inch length, which is required, I guess, by his faith. Over time, however, these Religious Freedom Restoration Acts have not been used to protect religious minorities as they were originally intended. They have gone now to, it seems, allow people to act in the name of religion in a way that impinges upon the rights of others. In the early 1990s, the original RFRAs, landlords were citing their Christian religious beliefs to justify refusing to rent a house to an unmarried heterosexual couple, because they believed that, if you're living together, you're living in sin. We had the Hobby Lobby case, which just came, before the United States Supreme Court decided in June of 2014. The Supreme Court extended the definition of a person, piggybacking on Citizens United, to say that a corporation, closely held corporation, could be deemed to be a person. And many states have, within their Religious Freedom Restoration Acts, permitted the definition of person to include corporations, businesses, and not just individuals who have religious beliefs, but the individuals who run businesses. And as such, these businesses are being permitted, or at least allowed under these RFRAs, to act as they do. What these laws have, and you've now seen this out in the press, florists, bakers, photographers, refusing to sell their services or use their services to cater to same-sex weddings. And that's really what the biggest hurdle is, and the biggest problem that we have with Religious Freedom Restoration Acts now, is that it is these beliefs, and these are Christian businesses for the most part. And if anybody has any indication that there are Muslim businesses out there that are doing the same thing, or Jewish businesses that are doing the same thing, please, by all means, let me know. But for the most part, most of the cases that we're hearing about deal with fundamentalist Christian businesses who have taken a stand against same-sex marriage, and as a result, they're choosing to not allow their services to be used by same-sex couples. It seems to clarify, or at least extend beyond what the original RFRAs were intended to do. Some might even refer to these new laws as a license to discriminate. It's not that easy. It isn't that easy. These states that have these RFRAs and these businesses that are seeking to use them to as swords instead of shields, they have to go through a judicial process. It's not a license to discriminate. They have to now go through a process. If they are fighting an anti-discrimination law or something of that nature, where a state is acting against them because of an anti-discrimination statute regarding these businesses, they have to go through a judicial process. They have to go to court, and now they've got to show the burden on their beliefs as a result of this, and they have to compare them directly with whatever the state's interest is in carrying out what this law was meant to mandate. This religious freedom that they're talking about here, to many civil rights advocates, is simply a code word for discrimination, and would not only inconvenience gay and lesbian couples, but in the view of most civil rights advocates, relegates gays to a second-class status. People who are pushing for the law have actually said that this will protect vendors who refuse to participate in same-sex ceremonies, and help them to avoid actions that will, according to their beliefs, be onerous and sinful to their particular beliefs, and to make them do so would be a violation of their free exercise practice. One might ask, however, in looking at these laws, the common question is how, if we're going to allow this, how far back do we have to go, and how quickly do we get to a point where these public businesses can say that for religious reasons they're refusing to serve an interracial couple? Do we go back that far? Are we triggering that potentially? The state RFRAs are much different, potentially damaging in a way, than the federal Religious Freedom Restoration Act, which, by the way, as I said, was a bipartisan effort signed by a Democrat president, and one of the signatories to Illinois' Religious Freedom Restoration Act back in the late 1990s. I believe it was 1998. One of the signatories and one of the voters on that law was a young gentleman by the name of Barack Obama, serving as a state senator, who became the 44th president of the United States. He signed off on a Religious Freedom Restoration Act in Illinois. What you see now with these state laws, however, is a significant expansion beyond what the federal government's RFRA allows. They broaden the scope of what is considered protection. They broaden the scope to religious businesses. They broaden it to for-profit businesses and not just non-profits. It's one thing if you're asking a church to mandate a church or some other religious organization to conduct a marriage or to conduct a wedding. That's something that we don't do. But when you're talking about for-profit businesses, then you have to deal with whether this is allowed or not. If there's a for-profit business that's substantially owned by a group of a particular faith, like Hobby Lobby, they're also broadening the definition of what state action means. It's basically it doesn't have to be just a judicial action. It can be anything that's brought to any court is now considered a state action. So what you have is a continuing expansion of Religious Freedom Restoration Acts that deals with the ability of local businesses to, in essence, potentially discriminate as a result of this narrowing test. And what we now also have is a further expansion. So how do you look at, by law, how do you look at whether a particular law is in violation or potentially in violation of your free exercise? There are tests. First, you have to ask yourself, is this government regulation, is this law contingent or some way dealing with a person's willingness to work on, based on conditions forbidden to their religion, like the Sherbert case, like the Hobby case in Florida with the guy building missiles, you have to look at that then, and at that point you're saying there must be a compelling state interest, and it has to be narrowly tailored, the least burdensome restriction. The second look that you have to give is, does this law apply to religiously motivated conduct? There was a case in Wisconsin with Jonas Yoder, who was an Amish gentleman who, at that point, Wisconsin and Pennsylvania had mandatory education laws for people who were after the 8th grade had to go to public schools or face a fine. But under the Amish faith, they didn't want their kids to be integrated into non-Amish connections, especially with school. And the Supreme Court in Yoder versus Wisconsin said that this parental right to not put your kids in school, along with this religious right, also dealt with your free exercise, and they allowed them to keep their kids out of school. If you have something related to that, a religiously motivated conduct, at that point, again, the law must be addressing a compelling state interest. That law has to be the least burdensome way of addressing that interest. Then you have to look at, does this particular law punish somebody because of their religious status? Such as, for example, a law that says that if you're a member of the clergy, you can't run for state office, something of that nature. You're being punished specifically because of a religious belief or a religious faith. If so, again, there has to be a compelling state interest, and it has to be the least burdensome thing in addressing that interest. It is this particular test that we'll talk about next time in addressing Muslim registries. Are you specifically discriminating against someone because of a religious belief? And if so, these laws have to pass a compelling state interest. And I'm wondering, and we can talk about this in our next ChrisChat scheduled hopefully for next Friday, whether in fact this is a violation of their rights. The fourth test you're looking at is, does this particular law target a specific religious conduct? Say you pass a law that says you can't bow down in front of a golden calf. There was a case after Smith, and I'm going to bollocks this name up, but the case of the Church of the Lukumi Babalu Ia versus Hialeah, Florida. Hialeah, Florida passed a local ordinance that made it unlawful for the ritual slaughter of animals. This was a law specifically directed at a Santeria practice of slaughtering animals as a result of their, as part of their religious practice. And they were fined and prosecuted as a result. And the United States Supreme Court said that although this law might seem neutral, it was in fact directed specifically at this practice. And as a result, Smith does not apply. And this was directed specifically at a religious practice. It was discriminatory in nature. And so, as a result, that particular statute, that ordinance, was tossed. So you can't go at someone because of their religion, because of their affiliation, because of a practice specifically related to a law that's related directly to their conduct, which is different than ingesting peyote, which is different than smoking marijuana. Nobody in the country is allowed to do that. That's a violation of the law. But this specifically dealt with this one ritual practice. And so it was directed at religion, and so it was not allowed. For any other type of law, any law passed by the government, what you have is simply a rational basis test. If there's any reason whatsoever for this law to be there, and regardless of how burdensome it is, as long as there's a rational basis for it, you are allowed to do it. Now, that deals with Religious Freedom Restoration Acts. But again, like we're seeing in many states, we're going beyond what is going on here. What you address is this. This is a bill in the Congress right now, sitting there waiting. This is House Resolution 2802. And the title of it is the First Amendment Defense Act. Now, you might, when I read it, think that this is a direct shot at same-sex marriages. And to a point, It is. But when I get a little bit through, you'll understand that this is a dangerous potential bill that is now waiting for a Republican-controlled Congress and a Republican White House and a potential conservative court to address. As I said, the First Amendment Defense Act states that the federal government shall not take or be allowed to take a discriminatory action against a person wholly or partially on the basis that such person believes or acts in accordance with a religious belief or moral conviction. A, that marriage is or should be recognized as the union of one man and one woman. So, now they want to create federal protection for anybody, any person, and the definition of person is further intriguing and potentially dangerous. So I want to stop right there. So this is a law that does not permit the federal government to act against someone or to discriminate against them if they believe that or act on the belief that marriage belongs to one man and one woman. They define person as any person, regardless of religious affiliation, including corporations and any other entities regardless of their for-profit or non-profit status. So they've allowed the definition of person to be, well, basically not just individuals, but a business, a corporation, a for-profit business, a non-profit business, whatever, what have you. They now allow this type of discrimination to be, or want to allow against federal discrimination against them, related to their belief, if they act on it, that marriage is reserved for one man and one woman. Now, you might think to yourself, well, it doesn't apply to me, this law, because it only applies to same-sex marriages. Incorrect. Let me move on to the second section of this. Not only do they want to allow for the prevention of the law from coming after them if they act on their belief that marriage is reserved for one man and one woman, but also if they act on their belief that sexual relations are properly reserved to such a marriage. What does that mean? What it means is, A, as we already talked about already, that if you are engaged in sexual relations with someone who is, if you're a man and a woman, you're allowed inside the context of marriage. This particular law says that a person, defined as basically anybody, can discriminate against you if you are a heterosexual couple engaged in sexual activity. It's not just, and not married. So all of you who are out there in the world who are not gay, who are engaging in sexual activity with a partner in a heterosexual relationship, you are now also a potential victim of discrimination if the First Amendment Defense Act passes. It restricts the ability of the federal government to attack you based on your business. If you are either a heterosexual couple, not married, or if you are a same-sex couple, married or unmarried, these persons, and the definition of person being an individual, a business, a corporation, a for-profit, a non-profit, basically anybody, they're allowed to discriminate against you, and you're stuck. So this is how far we've extended. This is where Smith has taken us, this backlash reaction regarding religious freedom. This is the dangerous part. When a law sits here, a law which was proposed just 2 days after President-elect Trump came down the escalator and announced that he was running for president, this law was put on the books, or this bill was put on the books for consideration. And some of the folks who've signed on as co-sponsors, Representative Chaffetz, who his name is out there as part of the future of the Republican Party, Trey Gowdy from Texas, Jeff Sessions, the Attorney General. All of these people have signed on to this law, among a host of others that I can show you to you, but you're probably not going to be able to read it. These people have all signed on to this bill, which in essence discriminates against anybody who's not married, that's a man or a woman. This is the problem. This is a potential problem. So in essence, what are we looking at now? We have a situation where under Supreme Court rules, you can discriminate against someone against their free exercise with a generally applicable neutral law that doesn't specifically go after a religious practice. If that law touches you and affects your religious practice, then the law takes precedence over your free exercise. But if it is directly related, if a law is directly related to your status, based on your faith, then that's something where the federal government or the state would have to show a compelling state interest, and that this law is the least burdensome way to advance that compelling state interest. I said to you that I would talk to you about what the different classes are, and this is another part of the problem. Who is protected? Who's protected? This compelling state interest test, this strict scrutiny, applies to what are considered suspect classes. Race is a suspect class. If you pass a law regarding someone's race or affecting someone's race, it's a suspect class deserving of strict scrutiny, this compelling state interest test. Your national origin, so laws relating to your maybe being, Syrian, is something that is a suspect classification. Your religious practice and your religious affiliation creates a suspect class, which is why the law deals with this compelling state interest. Your alienage, if you're from another country or you're from another political community, if it affects if it denies or dilutes your ability to vote, which is a fundamental right, any law like that, strict scrutiny applies, compelling state interest, least burdensome. Your access to courts or court proceedings are also dealt with in terms of strict scrutiny. And any other rights that are dealt with are recognized as fundamental rights. The Second Amendment, based on Heller and McDonald, is now considered an individual fundamental right, and so the Second Amendment protection also is covered by this compelling state interest test. At least I would argue that. If for those of you Second Amendment folks who think that I'm just sitting here chowing on guns, this protects you potentially. There's a group I didn't mention that is not covered yet, or maybe not ever, that is not covered by strict scrutiny in terms of equal protection, and that is the homosexual community. LGBTQ people are not considered a suspect class, at least as far as the United States Supreme Court is concerned. Oh, but wait, what happened with Obergefell and we have same-sex marriages now, and Justice Kennedy wrote this beautiful decision with flowering language about how this was a fundamental right and that these individuals are considered an insular class that has to be protected. The Supreme Court has not made at any point, have not officially said that this group is considered a suspect class for purposes of protection. Obergefell is out there. There are other cases that have discussed it, but it has never specifically been addressed. So right now, LGBTQ people are not getting this compelling state interest test applied on their behalf. They're in that middle tier in most of these cases. What may happen in the future is that we will have a direct case that deals with, are people in this community deserving of or considered a suspect class? And if they are, then the compelling state interest test applies. But until then, the protections for that community are limited. So that's everything that I wanted to talk about today. If you have any questions, I'll certainly take them. There are a few of you still logged in, so if you have questions about things that I've talked about already, or if you missed something that I talked about, please chime in and let me know. Otherwise, my plan for the next ChrisChat 4, will likely deal with the Establishment Clause. Very much entwining, where the line between church and state is drawn. And we'll talk specifically about the proposed Muslim registry and whether, in fact, this is a violation of equal protection, dealing with both free exercise and with the Establishment Clause. But I want to definitely get into the Establishment Clause next. I also want to get to symbolic expression very soon, addressing, as we've seen most recently, questions regarding flag burning and other types of symbolic expression and how you're protected. I have a question, whether atheism is considered a religious classification. Right now, atheism is not. Satanism is. At the beginning, I talked about what the court looks at in terms of a classification. What they do is they ask, does this person have a sincerely held belief in God or a God or some substitute that would take the place of God in terms of whether there's a belief or not, and that there's some moral compass that goes beyond the individual, something that is associational, that there is a group who believes this. My question then would be, or at least an argument that I could make or would make in terms of atheism, is in order to satisfy this definition under Seeger as far as religious and free exercise protection, is what exactly takes the place, because that's the language from Seeger, is what exactly takes the place of God or a lack of belief that allows this to be a religious practice, or at least a free exercise of. Lack of belief is not under the Seeger test, and I would encourage you to read it as always, but under the Seeger test, they require either a belief in God or some other equivalent that takes the place of God in terms of those people who were looking, in that case, specifically for a conscientious objector status. So when you're looking at the definition of Seeger, there has to either be a God or godlike figure or other substitute that takes the place of a supreme being, in essence. Which is why, incidentally, druids are covered, because nature takes the place. The earth takes the place. Satanism is covered because there's a belief in a figure that takes the place of God. But if there is an absence of a figure or something that, like I said, steps into the shoes of God, think of it that way. And it has to be sincerely held belief, and it has to be associational. It can't just be, there's not the church of one. We can have an army of one, but we can't have a church of one. And it has to be something that has a moral compass beyond what you as an individual believe. It has to be something that goes beyond you. In the Seeger case, I don't want to go to war would not be a valid statement. For you to say, my beliefs dictate it from something larger, a larger circumstance that I believe in, that we shouldn't be, going to war, then that's what you're addressing. So if there are any other questions, I'll leave it open for a second. Otherwise, like I said, my plan is to discuss the Establishment Clause next week. And following that, we're either that or flipping and doing symbolic expression and flag burning, which should be a rollicking good time for some of you anyway. But at this point, what we're trying to do is continue to advance discussions of the First Amendment. It seems to be something that we're butting up against a lot in terms of flag burning, in terms of free expression and free speech on both sides of the aisle. And so it would behoove us all to have a better idea of what words to look for, what the different standards are before we, go off and address these things. What can we do about the FADA, I'm assuming, is the question that I'm getting. Well, it's sitting there. It's waiting on the docket. It has not advanced beyond the initial application and co-signing. But if it does advance, what you have to do, as you would do with any other law, start hitting your individual representatives. We're here in Massachusetts. I don't know that we would have a whole lot of signatories to that. In just looking at the co-sponsors, I don't see any Democrats on the list that have co-sponsored the bill. Unlike the Religious Freedom Restoration Act, both at the federal level and the state levels, at many state levels. Because on both sides, like we talked about, Religious Freedom Restoration Acts were designed to protect minorities, religious minorities, from being pursued or from being discriminated against. And now what's happening is this shield that was given to these religious minorities has now been converted into a sword and is being used by religious majorities to pursue other individuals and to pursue an agenda. And that's the dangerous part of Religious Freedom Restoration Acts, both at the federal level, certainly, which, although they haven't really used it there except for good, but many of these state laws are resulting in actions like you've seen in Oregon with the baker who doesn't want to, send a cake to a same-sex wedding, or the florist or the photographer who backed out of a wedding the day before. All of these issues are the ones that we need to address. But in terms of this particular legislation, bang away at your legislators. Make sure that they know what this says. It's a pretty bald-faced, straight-out potential statute here, a bill that could turn into a law. But what you have now is a Democratic absence in the Congress, or not an absence, but a minority in both the Congress, the Senate, etc. And you also deal with a now Republican president. What you have to hope is that if this law were to pass and were then to be challenged in the federal courts, that at some point it gets to the United States Supreme Court, and that there is not an imbalance in the court, something that we've talked about in the past two ChrisChats as being the real danger here. Is not necessarily the person sitting in the Oval, but what the person sitting in the Oval can do to the future of federal law in terms of the Constitution by how they populate both the United States Supreme Court and, in greater part, the lower federal seats that are still remaining to be filled, approximately 120 of them over the next year or so. So that's really what you have to look at in terms of going after this law. And that's pretty much it. So I've gone on for about 55 minutes now. If you have any other questions, I'll sit and wait for another minute. Otherwise, I thank you very much, those of you who chimed in. I apologize for apparently somebody who, I'll make these public in the future. Somebody wanted to share it earlier, and I'm still trying to figure out how this all works. But what I do after this is, after I've recorded it, I post it on my Facebook page, and then I do make it public. So if there's anybody who wants to pass this along, by all means, I make the video public and it can be shared at that point. And in terms of putting this on other platforms, I would be happy to do so if I can just get my old man brain around how to do that. If someone would want to give me the how-tos, I'll be happy to. Because, as I said at the beginning, the idea here is not to advocate. The idea here is to educate. There are far too many people out there who do not have the basics as to what your rights are and what's out there that could potentially damage or diminish your rights. So thank you, all of you who sat in, and thank you for all of your suggestions. Thank you for your questions. If you have questions after I sign off, by all means, post them on the video itself, and I'll address them directly. And again, thank you very much for sitting around and having a little ChrisChat.